on the EU and UK consultations on regulatory proposals to halt deforestation on products placed in the EU and UK markets. This webinar is by Fern, Civic Response, EcoCare Ghana, Foundation for Tropinbos Ghana, Sustainable Rural Development, Sustainable Development Institute, and Send Ghana. My name is Alexandra Benjamin, and I am a forest governance campaigner at Fern. During this 90-minute webinar, we will first hear a short introduction from Opedowusu-Ade, co-founder and managing campaigner at EcoCare Ghana. And then Nicole, my colleague, Sustainable Consumption and Production campaigner at Fern, will talk through the EU consultation. And then I will talk through the UK consultation. As for some house rules for the webinar, can everyone please mute themselves and also rename themselves so we can see your name and the name of your organization. You can do this by going to the 3 dots on your icon and then re-clicking rename. We would also like to leave questions until the end of the presentation. We would also like to prioritize questions and clarifications specifically from civil society stakeholders in producer countries, and would ask others attending to do so as observers so we can prioritize the questions from these stakeholders. Also, one final note is to mention that this webinar will be recorded and uploaded on our website, along with some other notes. So with that, I would like to pass it on. I'm going to share my screen. I'm going to pass it on to my colleague, Oped, one moment, from EcoCare Ghana, and he will talk through why there is a need for a specific due diligence regulation in the EU and the UK. Over to Oped. Thank you.
Thank you very much, Alex. And welcome to everybody who is joining this webinar. It's a privilege to be here. I will start my small introduction by setting a scene. And I believe most of you might already have some of these numbers already, but it's worth going through them. First of all, globally, the EU and the UK are responsible for about 15% of forest destruction through their consumption of commodities like meat, dairy, soy for animal feed, palm oil, coffee, and cocoa. The EU is the largest importer of agro-commodities in the world. And as a very influential bloc in the world, the EU and the UK have a responsibility to lead in finding solutions to the problem of deforestation, which they have in no small way also contributed in creating based on their consumption. It is worth noting that several attempts have been made in the past through voluntary commitments and mechanisms aimed at getting private sector to source responsibly. But as most of you might already be aware, these attempts have not yielded the expected outcomes. We are not saying it hasn't worked. It has worked to some extent, but it has not yielded the expected outcomes. And as someone who works in a producer country, I can say emphatically that based on our socio-cultural and political settings, voluntary schemes with all its best intentions will not produce the results within the time frame that we require. Voluntary schemes are meant to change behavioral patterns of individuals, and we might not be able to get people to that level of change in the time frame that we are looking at. However, there is a body of evidence that shows that mandatory mechanisms combined with some form of statutory due diligence requirements have a strong possibility of effectively minimizing deforestation. I didn't say halting it completely. I said it has a possibility of effectively minimizing deforestation. For now, we are not very concerned about the format such mandatory mechanisms will take, but rather we are interested in letting stakeholders know that we have reached a milestone that require regulatory systems to compel both producer and consumer countries to address the issue of deforestation in their production and consumption. The EU and the UK are uniquely positioned to use their overwhelming market share to kickstart such a global process of using mandatory mechanisms and properly design due diligence requirements to achieve this environmental awakening in both producer and consumer countries. This is necessary because we are sitting on a time bomb, and unless real solutions are found to the rate of deforestation, the planet will not survive the next 50 or 100 years. In conclusion, we strongly believe that there is a need for forest-specific due diligence regulation in the EU and the UK with strong corresponding producer country mandatory mechanisms that are underpinned by proper multi-stakeholder deliberative processes. And I think that the emphasis is on that it should be underpinned by proper multi-stakeholder deliberative processes. We have seen it work in the FLECT VPA processes, although people have argued that we haven't seen the actual change. But if you come to countries like Ghana, Liberia, and to some extent Indonesia that have gone through this multi-stakeholder processes of finding solutions to problems within the forestry sector, there are very, very concrete milestones to show that regulatory and mandatory systems do work. It is only then that real change and progress can be realized. Voluntary systems and schemes are good, but we have seen that it doesn't always produce the outcomes that are required. And so we are very, very confident and welcome this process by the EU and the UK to consult on developing a regulatory framework that will introduce a real due diligence processes, both in producer countries and in consumer countries. So on that note, I would, just as Alex said, welcome you to this webinar. And I believe the scene has been set for the webinar to begin. Thank you very much.
Thank you so much, Oped, for that really great introduction. And I now will switch to my colleague, Nicole, who will talk about the EU consultation.
Alexandra, thank you very much. Yes, you can see me now. If possible, I would also like to share my screen to animate the slides directly. Just a second. I have the PowerPoint open, but it's not sharing. As my PowerPoint is not sharing, Alexandra, I would like to ask you to do the slides. Okay, perfect, great. And yes, hello and welcome all again to the webinar. I saw in the chat a lot of familiar names. So I also see that a lot of people who missed our either Portuguese or French webinar last week registered for this English language webinar. That's great. It's the third in our series, and tonight we're still going to have French. But now back to the actual presentation. I first wanted to give a bit of a background to the EU public consultations. I know many of you are specialists and follow this dossier and together with Fern and other NGOs have long campaigned for this to happen. So finally, in July last year, the European Commission said yes, it's responsible for deforestation globally to a certain extent and would like to take action. In its communication to the Parliament and the Council, it has identified several axes of action. What has happened since then? Since then, an impact assessment has started. So the European Commission has tasked a consultancy to look at regulatory and non-regulatory actions. This is the so-called impact assessment, which will be important to then propose action by the EU. Next slide, please. So the questionnaire is about, that has opened for the public to also give their view on which options should be taken, is about 30 pages long. I'm sure that the answers to this consultation will then feed into the impact assessment that I have mentioned beforehand. But now let's run through the questionnaires that you, citizens, companies, and everybody available to access a computer can fill. So first of all, the EU asks again the question whether it should regulate on the basis of legality in producer countries' laws, or on the question of sustainability. And by sustainability, we here understand certain criteria that commodities that come into the EU must be compliant with. This could be zero deforestation, this could be international human rights norms and standards, including customary tenure, or whether it should do a combination of both. Next slide. So we have a set of questions in front of us. These are the 6 options that the European Commission in the questionnaire proposes as mandatory regulation proposals. The first one, in our view, the strongest, would be a deforestation-free requirement, or so to say standard or criteria that commodities placed on the EU market must fulfill. And the interesting element is here that in this proposal, it would include a prohibition element. So it would be illegal to place goods on the market that don't fulfill the to be defined criteria. Second is due diligence-based regulation, which would be similar to the option I've just described one. So a company needs to conduct due diligence through its supply chains that the goods that it places on the EU market fulfill the criteria. But here it's a bit of a less strong option because it would not include a prohibition. So the company could be fined or sued just based on their robustness or publication of the due diligence systems, but not on the actual placing of the goods on the market. Third, we have the option of public national legality verification schemes. This would be similar to the system in place for the illegal fisheries regulation. I think some of you are familiar with it. So in this case, there's an agreement, would be an agreement with the European Commission, European Union, and producer countries' governments on how commodity production would be observed in their countries. What information is being made available would be first checking, so to say, by the host country. And while this information is being made available, the European Commission or European member states could then enter into a dialogue with the producer country if it thinks that what has been agreed, like the commodity production to be deforestation free, is not happening, could issue, for instance, a warning, a yellow card system similar to the illegal fisheries regulation. So this has an interesting element, which would be a partnership element in defining jointly what would be assessed and entering in the dialogue before a good would be banned on the EU market, so to say. Fourth, public certification system. Fourth, just disclosure of information. So the company would just need to disclose the information, but then there is no further hook, so to say, to sue or hold the company liable. The sixth option, and probably the least strong one, is labeling. So we could imagine that similar to what's on front pack about dietary requirements, the EU is thinking about all the goods need to be labeled deforestation free, which we think would be confusing, but I'm happy to talk about this with you in the discussion later on. So 6 regulatory options. I think they're more or less strongest from 1 to least strong to 6, and happy to talk about them again in the discussion. Next slide. So we also, the European Commission in its questionnaire also asked its citizens and everybody else in this questionnaire whether it shouldn't do voluntary policy measures. I think Obed has set out very clearly on why this is not sufficient. We also think voluntary has been around for quite some time and is not cutting it. So we think that, again, with voluntary labeling, which to a certain extent is already happening, voluntary due diligence, which front runners are already doing, or using private certification schemes, even if there are new ones for beef, is probably not sufficient. But still, the European Commission is asking about these options. Next slide. So here again, we have non-regulatory measures, but here it's not the companies in the lead with designing certification or designing labeling. It's about public sector action. We think in any case, there would need to be a package of measures if there's regulation to be complemented by such public sector action. And some of them are already ongoing or would hopefully need to be beefed up. So these contain, for instance, proposals such as development and cooperation assistance to producer countries. This could include help to increase productivity or help design forest codes, you name it. Second, also very important, consumer information campaigns in the EU on the deforestation footprint of its products. This could be designed to consumers, so they know what kind of deforestation footprint beef has, or embedded products like soya have. There is probably a case to be had for more information to be out there. Green diplomacy, we know this is already happening, especially when there are free trade agreements to be discussed or to be signed. It could be another way of engaging on the dialogue with a producer country, but we've seen very recently in some of the discussions around EU-Mercosur that green diplomacy and promotion through trade and investment, like on the last bullet, have not been so successful in halting deforestation. Another option could be a benchmarking of country assessments. So I think this would be similar to what I talked about on the slide about regulatory proposals for this kind of observatory, similar to the illegal fisheries one. But here there would be no sanction mechanism, it's just information. Everybody could check how their country is doing. Next slide, please. I'd like to come back now on the questions on mandatory due diligence and what type of regulation is being consulted on, and also give a view of what's Fern's view is. So if we think about the first 2 options on the regulatory option side, there was the proposal for a mandatory due diligence system by companies throughout their supply chains. We think it's important that a product-specific approach is taken. We share this view with the NGOs we work in alliance with to advocate for this option. Because in contrast to the second one on the slide here, a sustainable corporate governance approach, we think it would be, it's only in the first option, it would be possible to define exactly what a product must look like, and hence have the possibility to then fine companies if they put the goods not complying on the market. The sustainable corporate governance approach is also being discussed in the European Commission. There's a different department in the lead, DG Justice, as most of you probably know. The difficulty is here, or let's say we think that both need to happen and they are complementary, because if we only have a sustainable corporate governance approach, which would require companies to do broad environmental and broad social due diligence, we fear that the issue of deforestation is being overlooked and could not be sanctioned. Next slide. So what are different stakeholders so far thinking about the options, either publicly, they've made their views available, or behind the scenes? I will talk about the Commission, civil society, the Parliament, and briefly the private sector. First, let's start with the NGOs. I think I've just made it clear that most of us would like to see a product-specific regulation, including criteria such as zero deforestation and international norms and standards, including customary tenure, to be able to sanction companies that place goods not conforming to these criteria on the EU market. What does the Commission think about it so far? Well, in a study preceding the communication, so in a study of 2018, the Commission has, or the consultants to the Commission have said that legislative action would for sure be the most effective, but they would have a higher cost and are politically difficult to put through. But since then, we have seen commitments in other policy documents to putting legislative action on the map. Behind the scenes, what does the Commission think about the due diligence-based regulation? They're a bit weary because they're assessing currently the implementation of the EU timber regulation. So while the EU has implemented a law on making it illegal to place illegal timber according to a country's laws on the EU market, it has seen that there's implementation to varying degrees in different member states. Fines are being applied in different ranges, or fines are not applied at all. So implementation by competent authorities in the member states is very different, and it's thinking about these implementation problems when designing a new regulation, hopefully. Next slide. So in the European Parliament, we currently have two very good reports in the making. They will soon go to plenary this autumn. Both reports, so one on the response to the European Commission's communication on taking action globally, and the proposal to take legislative action specifically, further the development of a due diligence-based regulation, which is very good. What has also happened is that the European Parliament has done its own research carried out by a consortium, including the Austrian Environmental Agency, that has tested a few options, so kind of done a mini impact assessment that is similar to the bigger impact assessment that the Commission is currently doing. And it's interesting what they have found. So while they find that the most European value added would be having a mandatory due diligence-based regulation, they, in their modeling, find that for halting deforestation, the best option would be due diligence for sure. With well, for sure, let's not say. Let's say mandatory certification for sure, with or without due diligence. And this is maybe for us what we see the worrying part. So we see here a policy bias. Next slide. Views on measures by the private sector. Yeah, I will make it short here. So far, companies which are trading in cocoa and to a certain extent palm oil, so big consumer products companies, consumer goods companies, have come forward calling for a mandatory due diligence to level the playing field among its competitors, which is very good. But where do they differ from the call by the NGOs? And that's the question of where liability lies. In going forward, it will be probably very important to see where and how liability is defined. So could just the pure existence and carrying out of a due diligence act as a defense against liability? So what if an investigation found that although the company has done a lot in terms of due diligence, has progressively implemented its system, still placed goods not conforming to the criteria on the market? Is it then exempt? This is a question that needs to be solved. Next slide. This is my final slide for the part on the EU consultation. I'd just like to point out that the consultation is open until 10th of December, so we still have time, and please take the time. It's a very long questionnaire, 30 pages. You need to register, and then it's available in all EU languages. I also wanted to say that many NGOs under the lead of WWF have put out a petition called Together for Forests, where citizens can fill a pre-filled questionnaire and send it off to the Commission, sharing their views on the impact assessment. So with that, I would like to hand back to Alexandra to talk about the UK public consultation.
Thank you, Nicole. So right now there's also a UK proposal open on due diligence for forest risk commodities. There has been a lot of political lead up to this moment. Over 2 years ago, the UK announced a 25-year environmental plan, and in this plan, the government committed to a cross-government global resource initiative to work with businesses, NGOs, producer countries, and intermediary countries. And this initiative, called the Global Resource Initiative, started and lasted 9 months. It was supported across the government in partnership with the Department for Environment, Food and Rural Affairs, Department for Business, Energy and Industrial Strategy, and the Department for International Development, which is now called FCDO. The task force was led by Sir Ian Cheshire, and it was also made up of leading businesses, environmental groups, to really consider how we can reduce the climate and environmental impacts of key UK supply chains. During this process, there was some consultation, a lot of consultation of thought leaders, and what happened is the task force formed subgroups on areas such as monitoring, policy, finance, trade, carbon markets, and a cross-cutting group on gender, human rights, and social equity, which I was lucky to be a part of. This process packed in a lot of thoughts from UK stakeholders. However, there was not a lot of time made for the consultation of national civil society stakeholders. In addition, among the subgroups, there were some issues of contention in which we did not agree on. However, there were many issues and areas where the task force did come to agreement. And one of the major recommendations from the GRI final report recommends that the UK government urgently introduce a mandatory due diligence obligation for companies that place commodities and derive products that contribute to deforestation on the UK market, and to take action to ensure similar principles are applied to the finance industry. After the report was released, there were some concerns raised within government, mainly on its potential effects on trade agreements, the potential economic effects on small and medium enterprises, and there's a major concern around sovereignty, meaning that the UK government does not want to be seen to be telling other countries what to do. They want it to be a back and forth process. This report, however, finally led to this release of the current consultation on due diligence for forest risk commodities, which, as I said, is led by DEFRA. Now, the consultation has 4 different sections. Section A and B are about information on the individual and the organization. Section C is just for business. So I'm going to focus on Section D, which is the best opportunity for civil society to provide a response to the proposal put forward by DEFRA. There are 5 multiple choice questions for which you can respond yes, no, or don't know. They ask for your opinion on whether the government should introduce legislation designed to make forest risk commodities more sustainable, whether it should be illegal for businesses to use forest risk commodities in the UK that have not been produced in accordance with relevant laws. It also asks your opinion on whether businesses in the UK should be obliged to have a system of due diligence and be required to report publicly on their system of due diligence. Then there's a 6th multiple choice question, and it asks you or the organization, should the legislation apply to larger businesses? And there you're able to respond yes, no, or other, and there's an open answer section that doesn't have a word limit. Then there are 2 additional open answer questions. The second open answer question we believe is the most pertinent to national civil society, which reads, do you have any further information or comments you'd like us to be aware of? As I said, the open answers have no character limit, so it's there that you can provide your explanation of your thoughts and your responses to the proposal put forward by the UK government and your reactions to it. Now, as mentioned, the UK has put forward a proposal that you now have the opportunity to respond to. The UK's proposal is much more focused and limited in scope than the EU. It is legality and fine-based, meaning it looks to prohibit larger businesses from using forest risk commodities that have not been produced in accordance with laws in the countries where they are produced. And it also empowers the Secretary of State to levy fines on businesses that do not comply. Since it only targets larger businesses, small and medium businesses would not be in scope. However, larger businesses would be required to undertake due diligence on their supply chains and publish the results. The proposal also suggests to provide a pathway to recognize countries' national standards and other certification schemes as a way of satisfying due diligence. 2 of the main takeaways that we have as FERN are that human rights are not in scope. When they say that they would prohibit larger businesses from using forest risk commodities that have not been produced in accordance with laws in countries where they are produced, they also mean a narrow set of laws that are meant to protect specifically forests and other important ecosystems, and that are applicable to all forest risk commodities other than timber. The final main takeaway is that they would only prohibit larger businesses, but this does not mean they are prohibiting financial institutions. So human rights is not in scope, and financial institutions are not in scope of this proposal that has been put forward. In order to officially respond, you have to send in your response to the survey by 11:59 p.m. British Summer Time, 5th October 2020. All responses have to be made in English. If you'd like to submit an unofficial translation of the survey in Brazilian Portuguese, Bahasa, Spanish, or French, we have them available on Fern's website. These translations were made possible by a group called the UK NGO Forest Coalition, and they're also available on their website, which I have at the bottom of this slide. There are also 3 ways to respond to the consultation officially. You can either use the consultation link, which should be in the invitation sent to you from this webinar. You can physically post in your consultation in the mail, or you can directly email your reflections to DEFRA's Sustainable Commodities team using the email provided on the slide. Now, under UK government processes, unfortunately, submissions to the consultations, the individual submissions, will not be made public. However, if you would like to submit a response, we urge you to do it directly to the UK government. However, we're also really concerned that every single voice is able to be heard and their specific views. So the UK Civil Society NGO Forest Coalition has set up a web page to publish submissions so that they can be viewed publicly. And so if you have a copy of your official submission to the UK government and would like it to appear on the NGO Forest Coalition website, please contact info@ukngocoalition.org. And then you can not only officially submit your response, but also have the opportunity to send it to other people for people to view your reflections to the consultation. Now, what are the next steps after the consultation closes on 5th October? The government will issue a formal response to the GRI report in autumn. The government will also summarize the consultation responses they receive within 12 weeks of the consultation closing. If the consultation responses support legislation and the government chooses to move forward with legislation, there will be something called primary legislation. Now, primary legislation would give the UK government the power to do 4 things. Prohibit larger businesses from using forest commodities that have not been produced in accordance with laws in countries where they are produced. Require those businesses to undertake due diligence on their supply chains and publish the results. Empower the Secretary of State to levy fines on businesses that do not comply, and provide a pathway to recognize countries' national standards and certification schemes as a way of satisfying due diligence. Now, after primary legislation, there would be a second consultation before secondary legislation, and secondary legislation would define more of the fine detail, such as which commodities are in scope, the size of businesses that would be in scope, specifically what does large businesses mean, and the exact requirements needed in terms of due diligence. And that second consultation would provide another opportunity for stakeholders such as yourself to get involved and provide some responses to what you think of this consultation. Now, that concludes the UK presentation. Thank you so much for listening to all of us explain the need for due diligence, mandatory due diligence, and the EU and the UK consultations. We now really welcome clarifications or other questions, especially from national civil society participants. So if you have a clarification or a question, can you please pose it by typing it in the chat box? And it's really important that your name shows there. If you can also turn on your video so we can have a really active and lively discussion, that would be great. So now we'll wait to hear if you have any questions or clarifications.
Alexandra, I see that nobody has put a question per se in the chat, but I do see Jean-Francois's comment. And if I formulate it as a question, then it would be, does either proposal, UK or EU, be comprehensive to all natural ecosystems. We've talked about deforestation, but does the proposal or the questions also relate to other ecosystems? Would you like to answer for the UK?
Sure. So the UK proposal focuses on forest ecosystems. They've also said that they're looking at laws that also apply to important other natural ecosystems. We're not exactly sure what that means yet. The proposal would cover legality, and it would cover prohibiting illegal deforestation. So that means degradation may not come into scope here within the proposal.
Thanks. For the EU, well, in the parliament, the parliamentary report suggests that it would be good to go beyond deforestation and cover other natural ecosystems. In the consultation, there's also a question to that effect, but there is no proposal on the table. The consultation is more open than the UK one, so it's less easy to read the EU's bias at this moment in time.
Okay, there was also a question raised around whether we recommend going beyond legality, and also a question around the UK proposal. What would our view be on whether it should apply to all businesses rather than just larger ones? Nicole, I think you've already talked a little bit about why we should go beyond legality. Do you want to say a bit more before I go on to the UK bit?
I think that's fine, and as also Jean-François has put out, there are several problems with restricting the regulation to legality based on producer countries' laws. We have discussed this a lot in the webinar we've done with Brazilian organizations in Portuguese. Laws might not be strong enough or might be rolled back. So we would like to opt for international human rights norms and standards, plus spelling out very clearly what we mean by deforestation and not limit the proposal to illegal deforestation in a producer country.
Thank you. Read the UK due diligence proposal. We would suggest that it should apply to all businesses. There's been a few instances where member states have put forward a proposal and talked about whether their due diligence requirement should apply. They've had it only apply to a small number of companies, and it gets very confusing around whether those companies, which companies actually fall into scope. And it's very hard for even the government to ascertain which companies fall into scope. Also, under OECD regulation or suggestion, it says that all the businesses should fall into scope. It makes it a lot easier, and we agree with this type of analysis. We've also heard on a number of different webinars businesses themselves saying this doesn't make sense. Even as a larger business, we think that all businesses should come into scope because as a large business, that doesn't mean necessarily that I am importing a lot of deforestation. What about a smaller business that is concentrated on a product such as beef or leather, where they're actually importing a fair amount of these resources, whereas I'm a larger business and it may only be a small portion of my supply chain. Obed would also like to comment on this issue, so please go ahead, Obed.
Yeah, thank you very much, Alex. I want to comment on Francois' concern about going beyond legality. And the last one that he just posted, that in areas in producer countries where he believes the law is not adequate enough, what would be what would be the recommendation? What I can say is that when you look at what has worked in the past, for example, when you look at the FLECT VPA process and other processes, it didn't only limit it to the EU regulations, but there was a counterpart or corresponding reform in producer countries. The truth is that the EU, the UK can set all the regulatory frameworks in the consumer countries, but if there isn't a commensurate processes in producer countries to ensure that laws and systems are working, then we will not get the results that we need. So it should be a two-way affair. In as much as the EU and the UK are setting up their regulatory due diligence processes, there need to be a conscious effort to empower and support developing countries to develop their systems, their legal framework, and make it better, and to respond to some of these requirements that the EU or the UK might want to put up. So that is what I want to say to that.
Thank you. There's also a question in the chat. Will there then be rewards for companies willing to go beyond avoiding turning blind eyes to products in deforestation areas to reforestation or afforestation, perhaps looking at how marginalized communities can benefit from the policy and do not encroach further? With the UK due diligence proposal, one of the things that they have said over and over again is that this mandatory due diligence portion is only one part of how they view avoiding deforestation and prohibiting it. In the Global Resource Initiative, there's also a number of different ways that they've outlined, and the task force has outlined taking deforestation out of our supply chain, such as roundtables and overseas development aid. And one of the things that they'd be concentrating on, the UK government that is looking at overseas development aid as a way of supporting communities and small stakeholders to comply with due diligence recommendations and proposals. However, I don't think there is a reward system in place for going beyond. It's really more so a fine-based approach for those who do not comply. And in that secondary legislation, there would be an explanation of how to comply with the due diligence regulations, especially for businesses. Nicole, do you want to talk about that? And then there's also a question from both ends. For those of us not so focused on EU processes, could you please clarify how this deforestation reform process, including potential environmental and human rights due diligence, relates to the broader EU corporate due diligence discussion that is going on?
Okay, thanks. I'll start with that one. Yeah, thanks, Michael, for the question. Yes, not all of us are following this so closely. So as I've tried to explain in the presentations, there are two processes going on in the European Commission, one by the Department for Justice and one by the Department for Environment. So let's say there are two different lead departments looking at two different types of regulation. So the DG Justice one looks at what you describe as the broader corporate due diligence, which is also happening in certain member states or also other European countries, not EU member states. So asking companies more broadly to do environmental and social due diligence, or only human rights due diligence, as it's often framed. And this contrasts to the regulatory proposals that we would hope would flow from DG Environment, so the Department for Environment in the European Commission, where it would propose, or we hope it would propose, a regulation based on product criteria. So let's imagine a case where a soya importer faces two types of regulation. So the company placing the goods on the EU market, if both regulations were to be adopted, would need to have a very broad plan on how it ensures that there's no environmental harm in its supply chain, and or how there's no human rights violations. But in addition to that, it would need to prove that the soya it is importing is hopefully deforestation free and also free from, for instance, tenure violations. How would you need to do that? There would need to be very strong traceability and transparency in place. We think that, for instance, ID numbers, property level ID numbers could be asked from suppliers. We'd hope that producer country governments would make that mandatory for farms to have such ID numbers and give them when they, for instance, export to the EU or other countries. So it's similar, but different requirements. One very broad on environmental harm, which in case law, and as we see in France, has no guarantee that a company can be held liable for having deforestation in its supply chains. While there are lawsuits going on, we still have to see how France's justice system will rule on suspects of deforestation in supply chains, while as with a law specific on products criteria such as deforestation, we think would have more effect with relation to deforestation.
Great. There's a question regarding, I think I understand it. If I don't summarize this question correctly, please let me know, Aditya. What if there is a case of an area that was deforested, yet the local communities and related stakeholders, such as government and local NGO or CSOs, working hand in hand on reforestation by planting productive commodities such as cocoa and coffee? How does the UK market treat the products after due diligence? So I think if I don't answer your question fully, please just unmute yourself and ask me more, or Nicole for that instance. But since what will happen is that the UK government will define a scope of laws per country that are focused on forests and focused on natural ecosystems, and also are cross commodity. And looking at those laws, those nationally recognized laws, then they will decide whether a product was produced legally or not. And I think that is at the time that it was produced. So it would depend on those national laws. It wouldn't depend on some type of international standard that the UK is setting forward. And that's one of the issues, is because there's so many national laws. It's going to take a lot for companies to understand each single one and how that works in every single context. It will be up to them to sort that out and figure out how to comply with this due diligence. And also in that secondary legislation, there will be more of an explanation of how to comply with that due diligence. But I don't know specifically, it would have to be country by country about whether their national laws would make it so it's no longer, if there was any type of remediation clause or something like that, that would make the product not having been produced illegally, for instance. Hopefully that answers your question. If not, please unmute.
I'm seeing a question by James Hewitt about a threshold date for deforestation. I think this would only apply then to the EU law if it did not choose legal deforestation as per the producer's country's laws, because in the legal deforestation you would have the cut-off date. If we imagine a case that the EU rules based on zero deforestation, yeah, the question of date of clearance comes up. What has been discussed in other webinars and by private sector is that they would like to see different dates for different commodities, depending, yeah, on the context. And we also see a push or a proposal to put the date for when the regulation is being adopted. So either a date in the future, like 2023, if when the regulation might pass, or 2020 because of its previous international commitments. NGOs are pushing for dates like 2008, which academics and other practitioners say will be very difficult to implement, and would rather opt for 2015 because anything that goes back a lot is really hard to trace. But we understand that, like in Brazil, there's soya moratorium for 2008. So in some cases it could work. So this is just to say that there is no definite answer yet on the cut-off date for deforestation, because it's not even sure that this is what the EU is gonna propose, zero deforestation, as opposed to illegal deforestation in the producer country.
There's a number of comments coming in to the chat as well. One is concerning environmental backtracking, so active deregulation in countries. There's also some comments about that legal reforms to bringing other legal requirements are great, but we, looking on reflecting the VPA process, this has been a long process, and how much forest will be left in the next 20 years to get legislations right. And then also a few other comments specifically about the fear of those pushing for certification, because some countries' legality standards overlook human rights and environmental protection. But without legality, it becomes difficult to enforce certification schemes. I propose the EU supports producer countries to identify gaps in their current systems, and through stakeholders' consultation laws and systems, they are developed to address these gaps. So just to briefly comment on that, I would say when it comes to active deregulation, we currently don't see a mechanism that's been put forward which would allow the UK to negotiate or work with a country if they are actively deregulating. For instance, in the case of what we're seeing in Brazil, we have a few comments in the chat about that. So that provides a really big issue around, if a country just makes almost all of its deforestation legal, then it won't really matter that the law is based on legality, because there still will be a huge amount of deforestation being imported in with the products that we get in the UK or EU markets. This is one of the major loopholes we see. And then responding to the length of time when it comes to the UK process, the next steps are that within 12 weeks, so around December, the government will respond to the responses they've gotten and summarize what they think are the best next steps. And then secondary legislation would come next year. And then one by one, they're expecting these commodities to come into scope. So they're hoping that quite quickly the products in this due diligence mechanism would be active, and it wouldn't have to take 20 years. However, if there are issues with this due diligence system proposed, or how it's actually legislated, the other thing that we could propose to include into the UK's proposal is a review mechanism, meaning after primary and secondary legislation, you could go through a review period to alter primary legislation to alter the original proposal. So if you think that this original proposal does not meet your criteria or could be done differently, one of the things you could add to the consultation is that we also think there should definitely be a review process, which would maybe, it would take a long time to get right, but it would also ensure that things are going to get right and have more consultation. And then the note about certification is that I would completely agree. There are gaps in national standards into local standards, and that's why Bern would support more of a overall zero deforestation standard rather than what is being proposed in the UK. Nicole, do you want to respond to any of those, or you can also go on to another question. Also, Opit, if you'd like to respond, please feel free.
Yes, thank you, Alex. I think Francois has come back with a series of other interesting points, which I'd like to address. I think it would be very, very naive on the part of the EU and the UK to think that they can resolve producer country governance issues through their own regulatory framework. It will not work, and I know I've seen a lot of producer country persons on this webinar, and they can help me with some of these contests. You can't just resolve internal governance problems with your regulatory due diligence framework. It needs to be work together with producer countries. I was in Berlin last year when the governments of Ghana and Cote d'Ivoire, they stated emphatically that they will resist any attempt by the EU to impose any form of regulation on cocoa. And for me, the way to deal with some of the issues that Francois is raising about safeguarding the rights of indigenous people and their lands and all that is inbuilt into the governance reform processes of producer countries. So the best way for me to address this is to have a system that also empowers stakeholders in producer countries to undergo processes aimed at addressing their challenges in their own countries. And I think that is a very, very, very important element that we need to avert our minds to, or else we can push for this EU regulation, which I am in support of in a way, but it might not lead to the reform and to minimizing deforestation in producer countries. So that is my take on some of the issues that Francois has raised. But I'm also happy to further talk to Francois about some of these issues because I think it's important that we get some of this context right. Thank you, Alex.
Okay, I'd like to turn to unmute. Should work better now. I'd like to turn to Michael's question about possible sanctions, especially by DG Environment. I have to say I'm not aware of what they're exploring in the background about a potential sanction because they're still exploring some of the impacts. I'm sure that there are discussions going on, but I'm unfortunately not aware. In the NGO Alliance, we would push for both, so civil and criminal liability. This has proven difficult in other countries which have already proposed legislation on broad due diligence or human rights due diligence. So we would expect it to be difficult to pass. On the process in DG Justice, yes, Michael, you remember, right? There was a lot of talk about directors' duties. If I understand my recent chat with European Center for Corporate Justice correctly, there has been somewhat of a backtrack on this, but I don't want to give here more of an answer because I might not be available, aware of the latest developments. So I'd be very happy to put all of those interested in contact with the European Center for Corporate Justice about the latest developments on the proposal.
I don't see any other questions coming in. We have some questions to you all, especially those from CSOs in producer countries. And I will share my screen now to share those questions with you. because we have roughly 20 minutes left until the end of this. So one of the first questions we had to everyone here is, what is your general reaction to the UK proposal, that being based on legality, human rights, that human rights are not in scope, financial institutions are not in scope, that it's fine-based, and then it's limited to larger businesses. If you have any reactions, please unmute yourself, and if you can, put on your video so we can see your face. I don't see anyone unmuting right now, so I'm going to go on to the next question and perhaps put several different questions up, and then maybe people will have reactions to some of the EU and UK questions we're going to put forward. So we also have a question to the stakeholders here. Do you anticipate that this proposal would affect supply chains in your country? And if so, how? Then with the EU consultation, we also wanted to ask a few different questions. Which options seem the most promising to you to ensure the EU products placed on the EU market are free from deforestation and free from human rights violations, especially tenure? What potential negative effects do you foresee if one of the measures were adopted? And in your opinion, is there a way to encourage companies and suppliers to clean their supply chains, not just for their sales in the EU market, but also for other markets, preventing supply chain divergence? And finally, what package of measures would you recommend to the EU? So if you have any reflections based off of that or any other further reflections, please do unmute, and we welcome any type of comments.
Hello.
Hello.
Hi, everybody. Here quite early in Brazil. Yes, one on the UK consultation on the second question. We don't think that a legality proposal would change anything significant in the current trend of deforestation and human rights abuse, because it's quite a common requirement in the private business to have some insurance of legal compliance. And you can give legal compliance insurance, but if the legal compliance itself is not respecting human rights and allows a significant deforestation and conversion, then the change would be very little. Also, we had a recent study that showed that apparent legal compliance is hiding a very widespread illegality because of the complexity of the different laws. So it is really about what is pro forma legality and what is in real legality. So the response to the second question would be, it won't change anything of the current process. On the EU consultation, one impact would be that more than half of the actual habitat conversion is on non-forest ecosystems. So if you have a forest-only focused legislation, you can create very strong leakage on other ecosystems. And we have seen that happening between the Amazon and the Cerrado. So you had a moratorium in the Amazon, and at the same time, a steep increase of conversion of Cerrado, like you diverted part of the pressure from the Amazon to the Cerrado. And that can happen in other ecosystems on other continents as well. So that would be an effect of having only a focus on forests. Thank you.
Thank you. I also saw a comment by Elvis. Elvis, do you want to speak to your comment? It would be great to hear your voice.
Yeah, okay. I just want to say, with my small experience in community rights issues, I've realized that in every discussion, especially when it comes to natural resource, if the issue of rights and safeguards are not taken care of, those reforms usually fail, because people in the long run, because their life depends on it, when they realize that their rights are being abused, they resist this, and those reforms usually fail. So I think the issue around human rights should be a central point. In any way, we are protecting these resources because of our own good as a people. So if we are protecting the resources, the people we are protecting is for rights are being abused, then what's the essence of even protecting that resource in the first place? So I think human rights should be the central point of all these discussions.
Thank you, Elvis. I think that's a great point from the both of you. Does anyone else want to comment to the issues raised either by our questions or by the two people who just spoke just now? And Obed, you can also respond.
Okay, thank you, Alex. On the question and answer session, the EU consultation, the second question, which looks at the potential negative effects. What do we expect? What potential negative effects do you foresee if one of the measures was adopted? I looked at the various measures, and I think strictly going by sustainability might have a very negative, unforeseen situations on especially producers in Ghana and Cote d'Ivoire who are doing cocoa on 1 hectare, 2 hectare lands. Because in most cases, some of these international sustainability requirements are so laborious and difficult for ordinary illiterate cocoa farmers to be able to meet. That is why we feel it needs to be a comprehensive process, not only legality or sustainability, but let's find a fine blend between the two to ensure that it is addressing some of the fundamental problems on the ground. Because if you don't look at possible implementability of some of these systems and we forcefully impose them, we will be addressing one problem but creating a major one at the other end. And this I foresee, especially with smallholder producers in developing countries like Ghana, Cote d'Ivoire, that are into cocoa productivity. I foresee this could be a challenge for them. So the team should look at this comprehensively, taking into consideration what is on the ground and what is implementable.
Great. And I also see that Mercy, you also have your hand up. Would you like to speak?
Yes, I joined a bit late, but I want to make a comment on the third point under the EU consultation. I think that point is very, very important, given Ghana's experience with the FLECT process, because we are seeing that a lot of companies have now some interest in trading outside the EU with this restriction, and then the fact that we have not even been able to issue the FLECT license. So this question is very, very important for us to think through, so that it is not just about cleaning the supply chains with the EU, but with other markets. Otherwise, what may happen is that traders will look for other markets that do not have such restrictions as making the supply chain as clean as possible. So it is a point that we really need to think through critically, how to bring other countries on board in this process so that it will not just be the EU. I don't know whether there is a way of expanding this EU deforestation actions so that other countries outside the EU would also look at it as something that is of interest to everybody. So a universal action rather than just an EU action, because I suspect that in the long run, if the restrictions or if we are cleaning only the EU market, then traders will find other places to trade their agro-commodities. So it's not just about cocoa, but other commodities which Ghana already has experience in with trade in timber.
Yes, you raise a really great point, specifically around how the countries are doing outreach. And we've raised this as well with the UK government. They did some outreach to other countries during the Global Resource Initiative process. And now they're continuing to do that through COP26 leadership in the UK. So one of the reasons why they're basing it on a legality approach, for instance, on the UK, you mentioned the EU, but I'll just talk about the UK as well, and then let Nicole speak to the EU and what they're doing with engaging, is that the reason why they focused on legality within the UK is they felt this approach could be replicated by other countries such as China and India. And the reason why is because in the news, they feel like, and in their discussions with these stakeholders, that they do not want to intervene in national processes concerning legality over concerns of sovereignty. So they thought that perhaps in the lead up to COP26 and at COP26, they can use their leadership under their UK presidency of COP26 and also the momentum that they build to encourage other countries to also adopt a similar approach. Nicole, do you want to speak to this? And then I also see that Indra has a question to Obed, and I would encourage her to unmute and put her video on and ask him right after you respond.
Okay, thank you. To Mercy's question, we very much hope and push for the EU to uptake or make a stronger dialogue with China, who would like to be a leader on biodiversity. While there is a formal EU-China dialogue, we hope that this will be more used to the effect on discussing the issue of deforestation, and that China in the long run would also consider a law similar to a very ambitious law by the EU being adopted. So we think green diplomacy will definitely be needed here with China. As for other jurisdictions, there is a bill in the US Parliament similar to the UK's proposal. So this is what we are aware of from other big consumer markets.
Great. Indra, are you able to unmute? If you're not, then I will ask your question directly.
Yes, hi, I'm Indra. I'm the colleague of Alexandra and Nicole. My question to you, Obed, was indeed, we are also concerned that due diligence regulation may affect SMEs strongly and badly. And so what would be the right measures to be taken for them to be involved and to evacuate the risks? What could the EU and the UK do to mitigate that risk?
Okay, thank you very much, Indra. I think that is a very, very important question. And I think at the latter part of Mercy's submission, she typed a bit on that. There is a very broad base of informal and small-scale producers, especially in Ghana and Cote d'Ivoire when it comes to cocoa and other commodities. And the problem has always been that when we say consultation, when we are developing such regulatory or such mechanisms. We do consultation at only the higher level. So so-called representatives of farmers at national level meet, and they profess to speak on behalf of farmers. Whilst in actual sense, for me, the most pragmatic and effective way of finding solutions to some of these things is to go to the ground, have a bottom-up processes of kind of gathering information from the community level. Because from our experiences, and I think Elvis mentioned it, from our experiences, some of these national level representatives do not communicate to the issues affecting cocoa farmers or to coffee farmers on the ground. So the recommendation to the EU and the UK will be that in as much as they are doing consultation in their countries, in the UK and in the EU, there need to be also processes in producer countries to solicit for input from producers themselves. In Ghana, we went through a process that we call the forest forums or community forest forums, where we held meetings in all communities to get information from them that fed into national processes. I think that process will be very, very important in this situation to ensure that you are not developing regulations that will alienate the producers or that will indirectly affect their livelihoods. And so doing, you need to involve them in it. You need to find out what is it that you can do. What are the social safeguards that can be put in place to make sure that even if they will be worse off, there are systems in place to cushion them. And I think that is what I would recommend the UK and the EU undertake in producer countries before finalizing any of the options that they are looking at. I hope that addresses your issue, Indra.
Thank you very much, Obed. No, definitely, I would agree very much with you that the bottom-up approach is key. And maybe also to address Michael Rice's question, indeed, we strongly believe that the Commission should take this up and foresee maybe in partnership agreements as well some measures to accompany the SMEs, the smallholders, and especially women. But we also think that beside trade agreements, which may take time, that also the aid cooperation, the development cooperation, and the programming that is ongoing right now is an important opportunity to also influence. And I would strongly recommend also maybe Obed and everybody to reach out maybe to the delegations, also to listen how this programming is going and whether it's guaranteed that indeed some support to these key stakeholders is provided in the years to come. So yeah, I really think we definitely should also develop more in depth what exactly we are expecting from the Commission and maybe the UK in this sense soon. And also the focus on women here is very important.
Thank you so much for all of those points, and thank you for everyone who raised questions and came to this webinar. We really appreciate your participation, and it was a really live and rich discussion, which I hope will serve as momentum for all of us to respond to these proposals put forward by the UK and the EU. If you have further questions, please do not hesitate to reach out to Nicole and myself. We can also, if Obed is willing to provide you with his email or direct you to someone else if we don't know the answer to the question you pose. And we hope that this webinar will also lead to forums and national, in your producer countries, where you can get together and coalesce and discuss what you want these proposals to actually look like. If you want some more information, in our invite, we have a website link that has the information about this webinar, and we will also upload this recorded webinar to that site or a similar site and send that around with a thank you message to everyone who's participated. There will also be some notes and some links that we've provided in the presentation for the UK NGO Forest Coalition and those unofficial translations of the UK consultation are also already available on our website. Again, thank you so much for participating and have a great rest of your day. Thank you.